This is Immigration Attorney Peter Loblack from the Law Offices of Peter Loblack. We are located in Florida, in Orlando, and in South Florida, Plantation, Fort Lauderdale. Today we're going to discuss marriage-based green cards, and we'll touch on the topic removal of condition and also fiancé visa. It is important to understand that all marriage petitions are presumed fraudulent by immigration, both USCIS and the State Department through the embassy, the consular section. I will answer any questions that you have. You could send your questions to me. We will try to address as many questions as possible during our 1 hour period discussion. If you miss that period, you could always inbox me your questions, and as usual, we will answer your questions as we get them and in the order that they are received. We may take a little while because we are getting questions ahead of you, and we will always get to your question. But when we talk about marriage-based immigrant petition, what we are talking about is a petition for a spouse. And when we talk about spouse in the United States, we're talking about someone who's legally married. Now, same-sex marriages are recognized in the United States, and they are treated the same way as heterosexual marriages. So whether it's a same-sex marriage or heterosexual marriage, the U.S. citizen or the green card holder must petition for a spouse. Merely marrying a U.S. citizen or a green card holder does not confer any immigration benefit. That U.S. citizen spouse or green card holder spouse must file an immigrant petition for you and have to support that petition throughout the process. It is important to know that for any form of green card, when there's a family-based petition, an affidavit of support need to be provided. And we look at income or assets to determine whether that individual has sufficient funds in order to petition for that spouse, or children or parent, in whether the case may be. If you do not have sufficient income, it is your responsibility to obtain a co-sponsor, and that individual should have sufficient income. But the crux and the whole action in marriage-based visas are determined in the approval of the immigrant petition, the I-130 petition. And one must provide evidence or testimony to the satisfaction of USCIS or the officer at the embassy that the marriage is bona fide. Like all marriages, you should know something about your spouse. Obviously, customs and tradition in the country where you were married or where you're from are also taken into consideration. But the marriage must be a legal marriage. And to be legal for immigration purposes, all divorces or all prior marriages must have ended legally, whether in a divorce or through death of a spouse. So your marital history will be looked at, and you need to provide documentation on past marriages, how they have ended. Now, individuals always get into problems because when they apply for a visa, some individuals may say they were married. This may not have been true. They are now applying for a marriage-based petition on a spouse that was different from the one that they listed during the visa process, and now they have a problem because fraud or misrepresentation to obtain a visa is an inadmissible offense. And when we talk about inadmissible offense in the immigration context, we're saying that that offense, that past transgression, prevent you from obtaining a visa, and it prevents you from admission into the United States. So you could have a visa, But if you have an inadmissible offense, when you're coming through the airport, you're inspected, and the whole purpose of inspection is to determine whether you are admissible into the country. If you are inadmissible, depending on your circumstance, you will be sent back home. Some individuals will be admitted or not admitted at all, but they would be allowed entry into the U.S. and they would be required to provide documents to the satisfaction of CBP for inspection purposes. Some may be placed in removal and some will be detained. Now, if you are in the United States and you're married to a U.S. citizen, then you have the option to apply for adjustment of status in the United States. Applying for adjustment of status is not only, the only condition is not that you're married, you also have to satisfy the other eligibility requirements for adjustment of status. And marriage is important. You need to be inspected and admitted into the United States. If you were not inspected or you were not admitted or paroled into the United States, you may not be able to adjust your status here. There may be other technical grounds that one could claim a waiver on or exemptions, but these are technicals and they are generally the exceptions, and your immigration attorney would advise you. And talking about immigration attorney, it is important to understand one thing. In the marriage context, you should take no chances. It is always better to have an immigration lawyer, an experienced, licensed immigration attorney handle your filing. It is crucial because that individual knows the process, they understand the process, and could guide you. I will answer a question, and the question is, if you're on an F1 visa and you marry a U.S. citizen, but no longer go to school, can your spouse file for you? If you're in the United States on an F1, that means you were admitted into the United States. So you were admitted, so you made that requirement. You could apply for adjustment of status, not only your spouse filing an immigrant petition, but you could file to adjust your status. The other requirements for adjustment have to be satisfied. If you came here as a student, you may be evaluated to determine whether your student status was legitimate or you just used being a student as a proxy to enter the United States. But you would be able to adjust your status, and I would say yes, you should, and you should go ahead and do so. And most likely your status could be adjusted. It is important to consult an experienced immigration attorney. That is absolutely important. But any admission in the U.S. in any status, except obviously if you came in on a C1 or D1, which is a transit visa, or you came on a D visa, which is a crewman visa, you may have some problems adjusting. You may be ineligible to adjust your status in most circumstances, but there may be exceptions, and these areas you always want to talk to your immigration attorney about. You always need to consult an immigration attorney. I know there are a lot of people giving immigration advice. Family and friends who went through the immigration process always believe they are very experienced in that process. And obviously they went through it, but one thing you need to understand about immigration, it is a unique area of law. And everything that we do and your eligibility will always be dependent on your own particular circumstance, not what your friend's circumstance was, yours. So it's always important to have someone evaluate, and when I say someone, I mean an experienced immigration attorney, evaluate your own personal circumstance to determine whether you meet the requirements, because the way you enter the country could be different. Your application process could be different. Your experience in going through the struggles in the U.S. as an undocumented person or an overstay could be different. So it is important. You know, some people may have arrests, some may have convictions. You know, all of those are factors that could affect you, and you should always consult an immigration attorney. someone would like me to talk about the fiancé visa, and I will get to that, and I'm going to address the issues about fiancé visa. Remember, it's still a marriage-based petition. So a U.S. citizen, and remember, fiancé visas are only for U.S. citizens and fiancés of U.S. citizens, not fiancés of green card holders. So a U.S. citizen would like to bring in a fiancé here, and the only purpose of that fiancé visa, you should understand, is to marry in the United States. It's not for vacation. That's a B1, B2. So you want to bring in your spouse so that you could marry in the United States. There are specific, unique requirements. One, both of you have to be available to marry. That means all divorces should have been completed and final. Two, you should have met in person, not on Facebook generally or other site. You actually have to meet in person within 2 years. So it requires face-to-face meeting, except obviously based on the culture or tradition in the country where you're from. So if these requirements are met, then you could apply for a fiancé visa. Now, applying does not mean approval. Like anything with immigration, simply applying for a fiancé visa does not mean you're going to be approved. You still have to show that the relationship is a bona fide relationship. So if you could satisfy the embassy official that it is a bona fide relationship and that you are admissible into the country, you still have to meet the admissibility rules. You also have to be admissible and eligible for a visa. You could get that visa. When you come into the United States, you have 90 days to marry. If you do not get married, that's it. You cannot get a green card under any other grounds in the United States. You have to depart. So one of the most important requirements, once you enter the U.S. as a fiancé on a fiancé visa, you have to be married within 90 days. Victor asked, my spouse will be leaving to the States from Nigeria by November 2017. Can she file for me when she gets to the States? I've already applied and was denied a visa in 2015. You recognize one of the important requirements here is that if your spouse resides outside the United States, then that spouse cannot petition for any family member, because the purpose of petitioning for a spouse is for family unity. You need to be united in the United States for that spouse to come to the United States to reside with you. So yes, if your spouse, who is a U.S. citizen, moved to the United States, she could petition for you. The process may take about a year, maybe 2 years, depending on your country, the backlog in your country. So that's possible. The fact that you went through the process before, you may have applied for visas before, all of that will be taken into consideration if you misrepresent any material facts on those applications. Remember, your history with immigration is important, because if there's any misrepresentation when you apply for any visas before, or it is alleged that you committed marital fraud before, you're not going to be eligible to enter the United States. So you could be married to a new spouse and the person petitioned for you, you will not be admissible. A question for Nyla, by Nyla, sorry. I got married 6 months after landing here. My spouse refused to file my papers. What can I do? Well, as I said in my opening expose, so to speak, your spouse has to petition for you. Merely marrying to a U.S. citizen confers no immigration benefits whatsoever. Absolutely none. Your spouse has to petition for you. Petitioning under the law is a voluntary act, not mandatory at all. So a voluntary act by your spouse to petition for you, voluntary act to go through the process to support your petition. Because your spouse, who is a U.S. citizen, could withdraw your petition at any time prior to you obtaining that green card, and the petition dies. So it is important to understand that just merely marrying is not sufficient. So the spouse have to file and have to support the petition, go to the interview, and that the spouse could withdraw the petition at any time. Now, people will say, well, what about abandonment? If your spouse abandoned you, that means your marriage is not a bona fide marriage for immigration purposes. Abandonment by a spouse is not going to help you in the United States to get a green card. If you talk about abuse, yes, that could help. You could maybe be able to file a self-petition if you suffer domestic violence or there's extreme emotional abuse in the marriage, and you could support it with documentation and evidence. You may be able to file a self-petition, but that is within the United States. And that also applies for parents and also for children. So it's important to understand. But your spouse has to support you. A question individuals always ask is this. And it's important to understand that question. Say, well, I was married. We were fine for a couple months. Then my spouse moved out. I'm still married to the U.S. citizen. We have not seen each other for 4 or 5 years. Could the person file for me, or could I get any papers? The answer is no. Your marriage will be evaluated as of the date of the application. And if your marriage is not a bona fide marriage, then you have issues. I'm not saying that you cannot have problems in your marriage. The law does not say your marriage should be free from problems. There could be problems. People could have separated and then reconciled. All of those are good factors and are important and are evaluated on a case by case. That's why it's important to have an immigration attorney present at your interview also. That's key. Also in preparing the application and in preparing you for the interview. Your immigration attorney is not going to manufacture a grounds for you to get a green card. An immigration attorney cannot lie on your behalf. They do not lie. Nor would an immigration attorney, or not me, in fact, support a lie. So everything in the interview could be explained. We're all humans, we make mistakes, things happen. So if there were infidelity in the marriage that caused a separation, but then you reconcile, that could be explained. It's not a problem to explain it in a human way. So one needs the confidence generally to explain their circumstance, and most people dealing with immigration anyway, even though the interview is not that threatening, are threatened by the whole prospect. Obviously, there are repercussions for lying and misrepresentation, but it's willfulness in lying. If your marriage is what they call a business marriage, obviously that cannot support immigration benefit. The marriage have to be bona fide. You cannot marry someone and pay the person to marry you so that you could get a green card just without any intent of residing and sharing your life with that person. That is not going to work, and most immigration attorney, ethical immigration attorney, would not do it anyway. And the attorneys who would be unethical to do that, and I know none, that's not going to help you. Now, it says, a question I have here, does the process take longer for permanent resident petition? Yes, if you're in the United States and you marry a permanent resident, you cannot adjust your status immediately because there's no immediate immigrant petition for you. And therefore, you cannot overstay in the U.S. to adjust your status on a green card holder petition, because that's a preference category and there are no waivers if you have no basis for a waiver. So if you're married to a U.S. citizen in the United States, yes, the marriage is a valid marriage, but you are not eligible to adjust your status until that individual becomes a U.S. citizen, and then you would be eligible to apply to adjust your status and may be granted if you meet the other eligibility requirements. Colin asks, if my husband have a green card, can he apply for me? No, which is the same question from another individual, but you got to understand one thing. Your husband could file for you, your husband could file, and when you talk file for you, we're talking about an immigrant petition. If you're outside the United States, your husband in the United States is a green card holder, he filed a petition, in 2 to 3 years you will be processed and you will get to the United States. That category was current before, so sometimes it takes less than 2 to 3 years. It may take a year to go through the process. Again, talking to an immigration attorney, consulting an immigration attorney is important in those regards. But yes, that's not a problem. The only difficult situation is if you're married to a green card holder, you visit the United States and you decide to stay. If you decide to stay, I would say that's not a good move, because you cannot adjust your status, you cannot get a work permit. However, though, if you came into the United States and the petition is current, and you're given 6 months, 4 months, 3 months, you could apply to adjust your status at that time, because your stay in the United States is legal. You have not overstayed. The problem is overstaying. Once you have overstayed, your spouse needs to be a citizen. I have a question from Victor. He asks, what if I'm in the US on a B1, B2 visa and my spouse, who is a permanent resident, she's a green card holder, apply for me when I'm currently in the US? Do I need to leave after my 3 months? The answer is yes. If you want to be able to come back to the US or get a green card in the regular 2 to 3 years, yes, you should continue. You have a visa. Continue to use your visa if you can. There may be some issues at the airport now and then. The officer may want to know, are you trying to stay here? They're going to see the fact that your spouse has filed an immigrant petition. But if you always honor the date that you say that you're going to stay, you'll be fine. And I know sometimes we get a little carried away with the fact that you have a return ticket for 2 weeks. You declare at the airport you're coming for 2 weeks. The officer may say 6 months, which is the standard. Your authorized stay is 6 months, and then what most people do, they run and they change their stay, their return ticket to 6 months. That if you're trying to keep that tourist visa, that's always going to be a problem, because no one stays in the US for 6 months if they're not working. So there are 2 issues when you have a tourist visa. Is the fact that you stay in here for 6 months. That means you're either working in the United States on your tourist visa, which is a no-no, or you're not employed in your country, and that's also a problem. That's a change in circumstance as it relates to your visa. So people always have that issue. They never declare that they come in for a month. They always say 2 months, 2 weeks. But if you come in for less than 90 days, generally that may not be an issue. It depends on your circumstance. But if you tell the officer at the airport your return ticket is for 6 months or 4 months, you may have some serious issues. You may be denied entry into the country. LaShawn, how are you? I know you're listening. Thank you. I have a question. My spouse called the embassy and asked them to cancel my already issued visa. Is that an issue? Well, remember, anything as it relates to visas, the consular officer make the determination. If you're already in the United States, so if you were issued an immigrant visa at the embassy, you depart and you're in the United States, you have your packet, and your wife called the embassy, that's not an issue. Embassy is not going to do anything about that. They may make some notes in the record. If you're in the US, you get a green card, a spouse say, I'm going to have them deport you, I'm going to write USCIS. USCIS is not coming to deport you. You went to the interview, the spouse declared that the marriage is a bona fide marriage, you were issued the green card, and now the spouse saying, well, he married me or she married me just for papers, they left me, etc., etc. They'll make a notation of it. When the spouse file either to remove the condition or for naturalization, that issue will come up, and one will have to deal with that issue at that time. But it's not an automatic deportation for you. And I know a lot of people ask me that question, you know, are they going to deport me? Could my spouse cause them to deport me? Could my spouse call immigration to deport me? You know, and if my spouse called immigration, would they come looking for me? Generally not, but in those circumstances, that's a problem marriage. And if you have a problem marriage, you know, and you're dealing with immigration, it is always wise to get clear advice. A lot of friends will mislead you because, and they're trying to do their best to help you out, but they just do not know. There are a lot of information, people saying whatever they want, but just get proper help, get proper advice, talk to an immigration attorney, one who's licensed, and you know, you'll be fine. A lot of things that we worry about, we should not be really worrying about them. We may have to deal with them at the appropriate time, and that's okay. We just need to get as much documentation about our circumstance so that we could present it and present a credible and what we call a colorable case. So the authorities make their mind up. And most times, with competent counsel, you will be fine. Another question. My fiancé was once married and now divorced, and we are going to get married. How soon can she file for me? There is no waiting period. If you're married to a U.S. citizen, one could file from after the ceremony. It's no problem. You know, you after the ceremony, you have your marriage certificate, you're fine, you're married to a U.S. citizen, you're eligible to file. There's no negative inference that you file quickly. You will wait undocumented. It's your obligation now, as soon as you have the basis to adjust your status, to try to adjust your status. Why wait around thinking, oh, they're going to assume I married just for papers? No. There's no negative inference or positive inference based on the fact that you file immediately. It's a non-issue. It is not that important. It is not a consideration whatsoever. The consideration is on the marriage, the bona fides of the marriage, how you met, how long you've dated, who proposed to who, and the intent when you marry. A question from Prince. He asked, after my green card, how long can I stay outside the United States? Well, remember, green card is issued to reside in the United States. You're making the United States your permanent resident. You are not visiting the United States. That's why you gave up the tourist visa you had. So it is your home. You could visit outside the United States, it's not a problem. You could conduct business outside the United States, is not a problem. You do not want to stay outside the country for more than 6 months at a time. You know, you may not want to do that. If you need to stay outside the United States for more than 6 months, it is wise to get a travel document that allows you to stay outside the country for about 2 years. It is not a problem to do. Always check. Because if you're trying to keep that green card, you've got to follow the rules. And the rules are simple. It's easy to follow. If you do not know what to do, you consult an experienced immigration attorney. And that's always going to be your best friend, your best ally, your immigration attorney, because that individual is going to keep you in status. That individual is going to protect you and fight for you and to make sure you're always on the right side. Is it easier to wait for a permanent resident petitioner to become a citizen before filing for their spouse? Well, it depends, and it makes no difference. If you're outside the United States and you have a green card holder spouse, the person filed for you 2 to 3 years you're in the United States. If you come to the United States and you overstay, then and you want to marry, you marry. But filing an immigrant petition for you does not confer any benefit to you at that time. And once you overstay, you cannot adjust your status based on marriage to a green card holder. So it is useless in that regard. You have to wait for the individual to be a citizen in order to adjust. That does not mean you cannot marry. Anyone could marry who they want. But if you're thinking of your ability to adjust your status immediately, it is not going to be that way. So just understand that. And that's because that's just the rules. Green card holder can petition for a spouse. You're outside the country, visiting back and forth, that's okay. You will go through the process and you'll eventually get here. But once you overstay, everything changes. You know, you're in a totally different category. And if you're being placed in deportation, marrying to a green card holder is not going to help. It's a citizen, because you cannot immediately adjust your status. And that's what the whole purpose is. How can you get legal status? And if you cannot get immediate legal status, then it is of no help. So, a question again is, I'm married to a green card holder. We've been married for 3 years. The individual is about to adjust his status right now, but he have problem. He have been denied, not adjust his status, he about to apply for naturalization. He has applied for naturalization, and his application for naturalization was denied. What do I think about it? Generally, when I hear the question, what do I think? Generally, I don't think anything about it, but I will tell you the immigration issues involved. Applying for naturalization does not mean one is going to be approved. You have to meet the requirement to be naturalized. So until you go through the swearing-in ceremony, that individual is not a citizen. So you cannot apply to adjust your status just because someone applied for naturalization. There's no guarantee the person is going to get naturalized. You know, it is not a foregone conclusion. It all depends on the person's background and circumstance, which I would have to evaluate. But marrying to a green card holder, you marry whoever you want. It's not a problem. Just know that there may not be immediate immigration benefit from that marriage. And that should not prevent you from marrying the person, because marriage is based on love, devotion, sharing life together, etc. And whether the person is a citizen or not a citizen should be generally irrelevant. But I know for individuals who are undocumented, it could be a relevant consideration. But at the end of the day, that is not the basis that we consider for marriage. I have a question here. My wife is a citizen. We live together. She has a disability, and she's on SSI, which is Social Security Supplemental Income. I overstayed. Can she help me get a green card? If you are married and you're in a bona fide marriage, then you're eligible to adjust your status, provided you meet the requirements for adjustment. One of the conditions is admission and inspection, and you overstayed. That means you had a visa. I'm assuming it's a B1, B2 visa, and that's a good visa. You could apply to adjust your status. Obviously, income is important because you have to provide an affidavit of support. I do not know what's her income. Also, assets are important because we could use either income or assets, you know, for the affidavit of support. But if the person, as I said earlier, does not have sufficient income, you could always get a co-sponsor. And a co-sponsor could be anyone who is a citizen or green card holder residing anywhere in the United States. So the fact that your spouse is on SSI may not be a negative at all. So consider those factors. You know, you may need a co-sponsor, whether the person is employed, you know, or not employed. Obviously, all those things are considered in determining whether your marriage is bona fide. I just want you to understand, you know, a lot of people marry individuals, and when a reasonable person look at the marriage, the issue is whether those individuals are compatible. We look at all of those things as factors, and USCIS look at all of those things as factors in determining whether to approve that petition or not. And you may have questions, you may have issues, you know, and they may need a lot of clarification. But at the end of the day, the government cannot tell you who to love. The government cannot tell you who to marry. That's one thing in the United States. You have a liberty interest and a privacy interest. You could marry whom you want. But because the law says or marriage is a fraudulent marriage, the authorities, USCIS, need tools in order to credibly discharge their responsibility. And they're doing their job. They're doing their job under the law. It is not something that you argue with or you fight against or you resist because you want the benefit. And if you want that benefit, just comply with the rules. They ask you to send the documents. You have to go through the questioning. Then this is the process. You just go through the process and everything will be fine. I have a question from Judy. She says she's a British citizen planning to marry to an American citizen and live in America. I have 2 children. This man is not my children's dad. Where do we go from here? Well, Judy, if you're married, once you're married, that individual could file an immigrant petition for you. If you happen to enter the United States and if you're a British citizen and you come in on a visa waiver, then you need to apply to adjust your status within the visa waiver time, the 90-day period. It's the best time to apply. I would always caution individuals, and a lot of people come in, they have visas, and they come in, as soon as they come in, they marry their fiance in the United States, and the person turn around and petition for them. Remember that there's also a rule. If you marry within 30 days of your entry into the United States as a visitor, the presumption is that you came with the purpose of marrying. That would be inconsistent with your B1, B2 visa, which is a visitor for pleasure. You see? So if you were coming to marry, you had the wrong visa. You needed a fiancé visa. So there's the issue about marrying within 30 days and marrying within 60 days because the laws create certain presumptions in order to help the authorities guard against marital fraud or the misuse of visas or people applying for certain visas for the wrong purpose. All visas are issued for a particular purpose and they're purpose specific. So the evaluations are made as to intent, and the law presumes intent. And a lot of individuals say, oh, they do not know what was in my mind, I could just tell them anything. But we know it's difficult, but there are certain presumptions that the law make in order to help those individuals, rather to help the government enforce its rules and regulations. One thing to understand, and I know a lot of people say, well, I go to that interview. Well, me and my wife went to that interview. They ask us a few questions, and the officer then attack us and say, well, that marriage is no good. She not believing that this is a proper marriage. And as a result, she's saying, you guys have to tell me more or show me evidence in order to approve. And obviously that set a bad note for them. And so they're scared because they're already on the defensive because she said the marriage does not appear good and everything goes down. They're all nervous now, shaky, and interview did not go well. I hear that story a lot. I hear stories where individuals say, well, I went to the interview and another officer came and he showed a handcuff, and said someone is going to jail today. And I got denied. Everything went downhill after that. I hear those stories, but none of those stories do occur though when you have a lawyer present with you at the interview. Your lawyer is there to protect your rights. None of those things happen. It always happens when individuals tell me that they went to the interview on their own. Sometimes it's difficult to believe. And as a result, the U.S. citizen may withdraw the petition. The officer say, hey, you should withdraw that petition because this is a fraud marriage. Or the officer say, oh, you did not know this thing about that your spouse. How come your spouse didn't tell you X, Y, Z? And, you should withdraw, and people go ahead and withdraw. I always say to individuals, nothing good comes from withdrawing a petition. You went there, you filed, you know, you believe your marriage is a bona fide marriage, you go through the process. Let the government make a decision. Let the officer make a decision. Then you have an opportunity to respond to any negative denial. You could file a motion to reopen. You could appeal the immigrant petition. The law accords you certain rights, and you may not know your rights, but a lawyer would help you understand your rights. So it's important to always get the right information and to always guard, because I will tell you, it is always better to go to that interview, 15 to 20 minutes, you're out of here, everything is okay, than to go get a denial and go through the process. You always want to do it right. You have one opportunity to do it right, and that's the first time you apply. You know, so it's important to give yourself that opportunity to get it right the first time. The denial creates a history that you have to overcome, and you really do not want to be in that situation. I know we all hope for the best, but sometimes the best may not come, and you know, it's problems. Gobina asks, hello, I'm a foreign student with an F1 visa. I was married to a U.S. citizen, but my application was denied because my spouse withdrew the petition on the basis that she thinks I married her fraudulently. Can you get married again to another U.S. citizen and easily adjust your status? I would say adjustment, there's nothing I would say about adjustment that's easy, especially marriage petition. It is not going to be easy. There is no automatic adjustment. You have to meet the requirement. So if your wife withdrew and she said that, I do not know exactly what she said. If she said that she think you marry her for papers, that in and of itself, using the word think, may not be deadly for you. However, you should declare that you paid her, or she declared that you had all, you know, that she have evidence and she present evidence that you marry her solely for immigration purposes, then you have a problem. You could marry someone else, you could apply, but you may have some difficulty even adjusting. But those things depend on the facts and circumstance. I would have to see the immigration file. I'd have to request your immigration file. I'd have to look at the documentation. I'd have to look at the decision in order to advise you. However, if you're in the United States, you're not documented, you're married to a U.S. citizen, whatever factual issues may be there, I would say retain an immigration attorney and apply, because that's your process. That's the only way you're going to know, that's the only way you're going to get benefit. You need to apply. Do not assume, you know, you could always marry. The issue is not the marriage, the issue is whether your petition would be successful, and those petitions are never easy, and one cannot just say, well, you're going to be successful or you're not going to be successful. Another question, how long after you receive your 10-year card can you file for citizenship? Remember, you could file for naturalization if you're married to a U.S. citizen and have a green card for 3 years. The 3 years start from the date of the conditional card. So you could always apply 90 days prior to the 3-year anniversary. So that's generally the rule. Otherwise, it's 5 years. You need the green card for 5 years, and you could apply 90 days before the 5 years. Now, I get a question, and it's a little twist on applying for naturalization. And that is, while I'm waiting, I got the conditional green card. I applied to remove my condition. It's 4 years now, and nothing yet. Can I apply for naturalization? Yes, you can. Under the rules, you can apply for naturalization, even though you have filed to remove your condition and it has not been approved. However, the files will be consolidated so that a decision would have to be made on the removal of condition to reach the naturalization. But yes, you can, and that may be a means of putting pressure and trying to get your case moving through the process. So that would be one of the ways that lawyers use in order to get you what you want. However, though, everything depends on the facts of your case, the circumstance in your case. And as evaluated, by a lawyer. It's not just filing. And a lot of people just file documents, they deny, they file again, they deny, they file again. They do not even understand why their application was denied, why it was rejected. They keep doing the same thing and repeating the same thing. You could file as many applications as you want. They're going to take the money, they're going to process it, but that does not mean your circumstance or your condition has changed. So, another question here. How long would it take to get a green card if you're married to a U.S. citizen but you're in removal proceedings? That's a tricky situation. If you're married to a U.S. citizen in removal proceedings, that does not guarantee you're going to get a green card. It all depends. Hopefully you have an immigration attorney defending you in your removal proceedings, because that is crucial. So if you're married and the I-130 is approved, then you could apply to adjust your status before the immigration judge, or you could have your removal case terminated and apply to USCIS. It depends on your case. It depends on the circumstance in your case. So it's crucial, but it all depends. The earlier you could get your immigrant petition approved, the easier you could adjust your status. But again, you may not be eligible to adjust your status. I have no idea why you were placed in removal. The grounds for being placed in removal could be one of the grounds that may keep you from getting a green card. You may be able to apply for a waiver too. So all of those are factors that one have to consider in order to get the right answer. I would say call my office, schedule a consultation. I do both telephone consultations and also in-office consultations. A lot of people do call me, and we do consultation on WhatsApp because it's popular for them and easy for them. You can call my office. It's on my page, or it's 407-295-0099. You could always call my office. You could also follow up with questions to me in the inbox, so you could do that too. A question from James. I'm from Haiti, and my wife is an American citizen. I came here illegally, and now I have TPS. My wife filed out the paper for me. And last month we went to the interview, but I got arrested 2 months ago for drinking and driving. They sent me a letter and asked for more documents, etc. Okay. Individuals on TPS, if you came here on TPS, you may be able to adjust your status depending on your circumstance.
What was TPS?
TPS is temporary protective status, and that's granted to specified individuals by the president. So for Haitian TPS, he's on temporary protective status. He's in the United States. Now, you may be able to adjust your status. You're in removal proceedings, so there may be a base for that could create some issues for you, the removal proceedings. Being arrested for DUI could be a factor. There's a discretionary grounds, obviously, for denial of adjustment of status. You do not need a conviction. USCIS have to you don't have to determine in their discretion to grant you adjustment of status. So that arrest could be a factor. I would trust that you have an immigration attorney. It is crucial if you're in removal and you're in your situation. It is important that you retain an immigration attorney to handle your matter. It's not something that you should try to do on your own. Have a licensed immigration attorney who would go to immigration court, who could go before USCIS, understand the process to help you out. It is crucial. I see too many individuals trying to do it on their own, and like the saying goes, if you have yourself, if you have yourself for your client, you have a fool for a lawyer. But I am just trying to tell you, importantly, have a lawyer. The government have a lawyer in immigration court. They're the lawyer trying to deport you. And you have the right to a lawyer. Also, USCIS, in your circumstance, TPS, being arrested, there are technical issues that you need to overcome. So, do yourself that favor. Call my office or call any other immigration attorney of your choice, but get one. A question for Leslie. I have the option of marrying my fiance or letting my son file for me. Which is faster? This is the same category of a petition by a spouse or a petition by a child is the same. The only difference, if your spouse petition for you, then you get a conditional green card. And then you have 2 years before the expiration, you have to file jointly to remove the condition. If your son who's 21 petition for you, you get a permanent 10-year card. You don't go through that condition. So there's that distinction, and I would say your son, that doesn't mean you don't marry. You couldn't still marry, but your son could file the petition for you, and you'll be fine. Have him call my office if you want to do that. It is 407-295-0099. Question from Nyla. My children, they're over 21 and are holders of visitor visa. Can I address your status as children? No, no, no. Once you're 21, you're an adult. So they're not children. So you have to be less than 21. So no, you can't. You could file an immigrant petition for them. Their wait may be about 7 to 8 years. They cannot overstay in the U.S. and adjust their status based on your petition. It is not going to work whatsoever, so no, it's not going to happen. The same thing when it comes to individuals who aged out, and if at the time an immigrant visa is approved, and I know your children are derivative and they've been waiting, and now they're more than 21, and you get the letter and they're not included. A lot of individuals ask, what can I do? Generally, if there's a miscalculation of the age requirement, then, and you could prove that there was a miscalculation, then that's fine. They could accompany you, they could be reinstated. However, if the calculation is fine as it relates to determining, their age at the time of immigrant petition approval, then you may have luck or you may not have, but it's only technical. There's no pleading, and I know individuals say, if you send them a letter begging immigration, would they reinstate the kids? No, it's very technical, and an officer cannot really grant you a green card or a visa against the law. Even an officer does, you do not have a valid document. So pleading a lot of times not going to help you, not in those circumstances, not in those situations. Now, a lot of people ask about what's my cost for adjustment of status. What's my cost? I have a consultation. I do charge for consultation. Telephone consultation is $100. For adjustment of status, and everything starts with a consultation. I have to understand your case. I have to understand your circumstance. You may not even be eligible for what you think you're eligible for. So that's why it's important to do a consultation. The lawyer go through your circumstance, go through your background to make a determination, whether you're eligible and whether he's going to take that case, what is going to require to provide you with the result that you need. Because the key is to provide you with results. And, and to get to understand you, get to understand your situation, get to understand your spouse, your family situation, in order to do the best job for you. So everything starts with a consultation, and the amount of work that a lawyer may have to do depends on your circumstance. So it is difficult to say, well, it's going to cost you X amount or Y amount, It is very difficult until one understands what we're dealing with. What's your circumstance? For some individuals, maybe a straightforward matter. So a lot of individuals, it's not. So, as it relates to cost, it's a little difficult to really articulate what cost. But I'll tell you, the fees, the attorney fees, and the costs are set by immigration. The filing fees are standard, but the attorney fees is the portion that the attorney charge in order to do the work for you. And that is always going to depend on your facts and circumstance. There's not like a standard rate, so to speak. There may be, and my office, I want everyone to understand, we do have payment plans for individuals. You could pay by credit card, you pay cash, credit card, any means you want. And there is always a payment plan to help you along. You pay a down payment and there's a payment plan. I have a question from Del Rose. I'm presently on a J1 visa. Is there a process which can help me stay in the U.S. permanently? Individuals who come in on J1 visas, they may have some issues because some individuals are barred from adjusting their status for 2 years, but there's no automatic conversion of a J1 into an immigrant petition. It's not automatic. You may have some issues as it relates to the 2-year bar. That means you have to leave the country and stay outside the country for 2 years before you could come back permanently to the United States. But there's nothing in immigration is a direct conversion. J1 individual, someone have to petition for you. Like all immigration matters, someone have to petition for you. You got to have an eligible person file a petition for you, or a business file a petition and go through the process. There are individuals who cannot overstay. There are individuals who can overstay, especially if you have an immediate relative petition. Then you could overstay and adjust your status if it's immediate relative. For immediate relative, we talk about a spouse, a parent filing for a child, and a son, daughter filing for a parent. These are the immediate relative criteria. Now, a few thoughts, additional thoughts as it relates to marriage that you're always going to know. You're going to do an interview, whether you do an interview at USCIS if you're planning to adjust your status, or you will have to do it at the embassy. Even though your immigrant petition was approved by USCIS and sent to the embassy could still find evidence that the marriage is not bona fide and send it back. So you would need to provide additional evidence, etc. But at the interview at the embassy, you always have to be prepared to deal with the bona fides of the marriage, how you met the person. You know, and sometimes the embassy may say, oh, we need your spouse who's a U.S. citizen to come to the interview and schedule you another day. And they may separate you guys, ask you different questions, etc. The same questions, but not in the presence of each other. So, and it's continuing when you get a green card based on marriage to remove the condition. Your marriage is still going to be tested, and also when you apply for naturalization, if you happen to divorce, your marriage, the basis for getting the green card will always be retested, you know, to see whether it was a bona fide marriage, because you cannot get naturalization if your green card was not issued legally. That's one of the requirements for naturalization. You have your residency have to be issued legally. Again, my name is Peter Loblack. I am a licensed attorney in the state of Florida. I have my office in the state of Florida, and I handle immigration matters throughout the United States and at all U.S. embassies and consulate. My office number where you could reach me is 407-295-0099. It was a great conversation today. For those of you who I did not get your questions, I was not able to answer your questions live, you could always inbox me your questions and I will get to them. As you could see, I am very proactive in responding to questions. So keep your questions coming. If you need specific immigration advice, it's important to call my office and schedule a consultation or request a consultation from our website. From the Facebook page, you could also do the same thing. You could request a consultation from our Facebook page. I have a lot of information on that page on all immigration topics. You may find it helpful to spend some time, go through them. All the posts and all the videos on my page, you could freely share them, and I encourage you to share them. I encourage you to pass them along to your friends. Have a wonderful weekend. Enjoy the rest of your Saturday. Enjoy Sunday, and we shall talk next Saturday.